Hi, my name is Elaine Buckley. I'm with the UCD School of Law, and my PhD thesis is based on the sufficiency of independent legal advice to commercial guarantors. My research addresses the current limitations of the legal advice given to guarantors. I hope to achieve a fairer, more just level of protection for them by formulating a more comprehensive regulatory framework of protections, both before and after the guarantee is given, including ways to make advice more accessible, relevant and personalised to each guarantor. This might be done with the introduction of an ombudsman for personal guarantees, with the power to investigate and reopen guarantees already given, or through the use of existing competencies such as MABs and the Citizens Advice Centres and other advisory services, in addition to enforced financial planning for guarantors and more proactive legal advice. A personal guarantee is defined as an undertaking to repay another person's debt. The person who takes out the loan is the debtor. The institution which provides the loan is the creditor. The person who gives this promise is the guarantor. A person who takes out a loan provides the institution with an alternative source of repayment should they fail to repay the loan themselves. In essence, you provide a hostage who will meet your obligations if you do not. And this is the actual historical precedent for guarantees. Usually guarantees include indemnities. This means that even where the contract is void or the creditor fails to chase the person who took out the loan, the guarantor must still repay the money. Recently, guarantees have been roundly criticised by the courts and throughout the media and by the general public, with many guarantors arguing that they did not know what they were doing. Guarantees are controversial as they must be provided by somebody in a personal relationship with the guarantor to be most effective. This leaves any potential guarantors open to emotional pressures such as undue influence in order to enter the contract. The current techniques for protection of guarantors is lacking and merely involves them receiving independent legal advice. While it is considered good practice for banks to insist on this, legal advice isn't mandatory in most situations. Benefits of my research include a more rounded and beneficial process of advice for potential guarantors. This will lead to their empowerment and will also have the effect of making personal guarantees fairer and therefore easier and less controversial for banks to enforce. Protections for directors will also further encourage commerce and preservation of existing businesses, including that of the banks.
Yeah.